For so many years, I've heard the common refrain that you've got to get retainers if you want to get paid. If you want to be assured that you're going to get paid at the end of your engagement with a client, you need to have a retainer. And that sounds really, really good. There's a problem, however, with that commentary, and that is that unless you have a non-refundable retainer, retainers have an inherent weakness under the rules of professional conduct. Let me tell you a little bit about what I mean. And the reason I raise this issue today is because I was reminded of it so recently by a client of mine who's being investigated by the state bar for the very issue of retainers. Now, in his agreement with the client, he calls his retainers non-refundable. By definition, non-refundable means you will not refund the retainer no matter what. The problem is that most agreements that I've seen between client and attorney provide that if the client is billed for fewer hours than is under the terms of the retainer, there will be a refund of the excess. So let's back up a bit. Non-refundable retainers are those retainers in effect that are non-refundable for any reason, meaning that those retainers are to assure the attorney's availability. There are very few of these in existence. And frankly, where I've seen them most often is in the marital dissolution or divorce proceedings, where you want to make sure that the attorney doesn't go somewhere else. In other words, doesn't represent the adverse party. So there you give them a non-refundable retainer. It's a relatively small amount, but it is effective. So if there's to be any credit given to the client for work not performed, hours not used, then that in effect is a refundable retainer. And the agreement does not control the definition of the retainer. That is a question of form versus substance, and we know under the Internal Revenue Code that the government just doesn't look at that. They're going to look at the substance. So will the court. It seems to me that one of the issues in terms of retainers that helps make sure you get paid is the concept of the evergreen retainer. In this event, you get, let's say, $1,000 for your client trust account. You do work that equals $1,000. Now, instead of doing more work, you have the client pay you another $1,000. That's the evergreen. In other words, the client trust account amount is constantly being refreshed so that you're ahead of the client. Another aspect of this issue of the retainer is that you cannot take any money from your client trust account where the client objects. So in other words, let's say you have, even under an evergreen retainer account in the client trust account, you bill the client for $1,000. The client objects. Now you have money in the client trust account, so theoretically you could write yourself a check for that amount of money. But under the rules of professional conduct, once the client objects to your bill, you no longer can take any money out of the client trust account. And interestingly enough, in the state of Wisconsin, one of the rules there is that you've got to give notice to your client before you can withdraw any money from the client trust account. And I think the issue there is 5 days advance notice. So not only do you have money in the client trust account, not only have you billed the client, but you now have to notify the client that you're going to pay that bill with money from the client trust account. And at any point in time that the client objects, you are prohibited from taking more money from the client trust account to satisfy that bill. So let's get back to the issue of the retainer and what I asked you in the beginning. Do retainers do any good for you? The answer is yes, obviously. What does it do for you? Well, number one, it assures you that the client has money. Has money to do what? Has money to get started. If you have an evergreen engagement agreement, then you presumably are assured that the client has money to continue the litigation or the engagement, whatever, if it's a transactional matter. What you are getting from the client is the assurance that they have the money to pay your bill. That's a lot better than working in the dark, but it does not, under any circumstance, assure that you're going to get paid. Frankly, if it were a question of whether to do the work for a creditworthy client, but one who didn't have enough money for your retainer right now, and somebody who had money for the initial retainer right now, but was not creditworthy, I'd take the former client, not the latter client. So be careful when you get into this concept of, pay up front, retainer, and so forth. Don't get all locked up into that fallacy. It's a dream in reality. The question then that I have in working with my coaching clients is, what can you do to assure that you will get paid? I mean, after all, that's the bottom line. The bottom line is not whether you have money in the retainer by way of retainer or money in the client trust account. That's not the issue. The issue is, will you get paid? Will you get paid all that you bill? Well, there are a couple of ways that issue can be taken care of, and we'll deal with that in another segment. Stay tuned.